I doubt it would surprise you that I watch a fair amount of videos that involve interactions with the police. One question that comes up is, when is an officer's attempt to search or detain someone reasonable? One of the cases attorneys frequently refer to is Pennsylvania v. Mimms. So I decided it was worth taking some time and reviewing that case. So we'll do that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your action generation to be free. I'm glad you could join me. This is an interesting case because, again, your Fourth Amendment rights to be free from unreasonable searches and seizures really comes down to what is and is not reasonable. So that's what we're going to look at today. You can find the written article with all the links to all my resources on the website constitutionstudy.com. I'll talk more about that and other ways you can follow and support the Constitution Study at the end of the episode. But for now, let's get into this case, Pennsylvania v. Mimms. To understand the decision, it's important to first understand the case. After police officers had stopped respondent's automobile for being operated with an expired license plate, one of the officers asked respondent to step out of the car and produce his license and registration. As respondent alighted, a large bulge under his jacket was noticed by the officer, who thereupon frisked him and found a loaded revolver. Respondent was then arrested and subsequently indicted for carrying a concealed weapon and unlicensed firearm. His motion to suppress the revolver was denied, and after a trial at which the revolver was introduced in evidence, he was convicted. The Pennsylvania Supreme Court reversed on the grounds that the revolver was seized in violation of the Fourth Amendment. Now, put yourself in Mr. Mimms' shoes. Personally, I expect the officer to ask the typical question, "Do you know why I pulled you over?" Instead, the officer asks you not only for your driver's license and registration, but to get out of the car. This entire case, along with the protection of your rights, comes down to whether or not it is reasonable for an officer to ask you to exit your car in that situation. The Pennsylvania court did not doubt that the officers acted reasonably in stopping the car. It was also willing to assume arguendo that the limited search for weapons was proper once the officer observed the bulge under the respondent's coat. But the court nevertheless thought the search constitutionally infirm because the officer's order to respondent to get out of the car was an impermissible seizure. This was because the officer could not point to objective, observable facts to support a suspicion that criminal activity was afoot or that the occupants of the vehicle posed a threat to police safety. Now, no one disagrees the officers had a valid reason to pull Mr. Mimms over, his expired license plate. Arguendo, by the way, means in the course of the argument. Under those circumstances, the officer also had a reasonable, articulable belief that a traffic violation had been committed. He was driving an unregistered vehicle. This also justified requiring Mr. Mimms' identification. But what was the reason to have Mr. Mimms get out of his car? The Pennsylvania Supreme Court stated that the officer could not point to an objective, observable fact to support criminal activity or that there was a threat to police safety. So what made the order for Mr. Mimms to exit his vehicle reasonable? The state freely concedes the officer had no reason to suspect foul play from the particular driver at the time of the stop, there having been nothing unusual or suspicious about his behavior. It was apparently his practice to order all drivers out of their vehicles as a matter of course whenever they had been stopped for a traffic violation. The state argues that this practice was adopted as a precautionary measure to afford a degree of protection to the officer, and that it may be justified on that ground. Establishing a face-to-face confrontation diminishes the possibility, otherwise substantial, that the driver can make unobserved movements. This, in turn, reduces the likelihood that the officer will be a victim of an assault. The state argues that it is reasonable to remove someone from his vehicle for the sole purpose that a face-to-face confrontation diminishes the possibility the driver can make unobserved movements. This is done for police safety, but what about the safety of the accused? So I can understand asking the driver to get out of the car, but only if there was an articulable reason to believe the officer's safety was compromised. We think it too plain for argument that the state's proffered justification, the safety of the officer, is both legitimate and weighty. Certainly, it would be unreasonable to require that police officers take unnecessary risks in the performance of their duties. This is based on Terry v. Ohio. And we have specifically recognized the inordinate risk confronting an officer as he approaches a person seated in an automobile. I recognize the dangers of police work. An officer is subject to risk every time they answer a call or pull over a vehicle. However, by the court's logic, every person accused could be required to be treated as a criminal without cause. Exiting a vehicle introduces risk to the accused. An unidentified furtive movement could easily lead to an overreach by police. A slip or stumble in front of an officer who has been trained that every encounter with the public could present an unnecessary risk could lead to dangerous police actions. In short, by training law enforcement that everyone is to be considered dangerous until proven otherwise, actually creates a dangerous imbalance of power, leaving the average citizen at the whim of law enforcement, without any way to protect themselves. According to one study, approximately 30% of police shootings occur when a police officer approaches a subject seated in an automobile. This is from the Bristol Police Officer Shooting, a Tactical Evaluation paper. While one study may show that 30% of police shootings occur during a traffic stop, that's not enough to show probable cause. For example, how many of those 30% of shootings involve people being pulled over for minor traffic violations? Has anyone compared that to how many of the registered owners of those vehicles came back with warrants? Even the court acknowledged the limitation of their data. We are aware that not all these assaults occur when issuing traffic summons, but we have before expressly declined to accept the argument that traffic violations necessarily involve less danger to officers than other types of confrontations. That's from United States v. Robinson. Again, by this logic, every police encounter should begin with handcuffs and a pat-down. I mean, if every encounter with law enforcement has the same level of danger as other types of confrontations, they should be treated the same. But again, is that reasonable? The hazard of accidental injury from passing traffic to an officer standing on the driver's side of the vehicle may also be appreciable in some situations. Rather than conversing while standing exposed to moving traffic, the officer prudently may prefer to ask the driver of the vehicle to step out of the car and off onto the shoulder of the road where the inquiry may be pursued with greater safety to both. This is a situation where it could be reasonable to ask, not demand, that the driver join the officer in a safer location. However, it is reasonable for a driver not to wish to risk injury by getting out of his vehicle into traffic. After all, a person's vehicle is their property, and really, is it all that different from your home? Furthermore, the officer has the ability to mitigate his or her risk of standing beside the vehicle by placing his vehicle where it can help shield him from traffic. He could also simply conduct his interaction from the passenger side vehicle. Vehicles aren't that wide that someone can't reach across and hand over a license and registration. Against this important interest, we are asked to weigh this intrusion into a driver's personal liberty occasioned not by the initial stop of the vehicle, which was admittedly justified, but by the order to get out of the car. We think this additional intrusion can only be described as de minimis. This is not simply a question of personal liberty, but of a constitutionally protected right, one which should not be violated without due process, which includes making sure a law enforcement officer has a reasonable cause to ask a driver to leave their vehicle before ordering them to do so. The driver being asked to expose to view very little more of the person than is already exposed. The police have already lawfully decided that the driver shall be briefly detained. The only question is whether he shall spend that period sitting in the driver's seat of his vehicle or standing alongside it. There is a difference between being detained and being ordered out of your vehicle. Would this logic extend to a person's home? Can law enforcement come to your home and order you to exit the residence? Furthermore, should law enforcement have other than honorable intentions? This not only exposes the accused to further harassment, but the physical intimidation of being ordered around without cause. Not only is the insistence of the officer on the latter choice not a serious intrusion upon the sanctity of the person, but it hardly rises to the level of a petty indignity, again from Terry versus Ohio, which is at most a mere inconvenience, cannot prevail when balanced against legitimate concerns for the officer's safety. I wonder if the judges who were pulled over for a minor traffic infringement find it a serious intrusion to be ordered to exit their vehicle without a good reason. Remember, this is a situation where law enforcement can and has been known to use their position to intimidate drivers into compliance, even self-incrimination. Now we get to the opinion of the court, where we read, respondent's motion to proceed in forma pauperis is granted. The petition for writ of certiorari is granted. The judgment of the Supreme Court of Pennsylvania is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. The court decided for the state and sent the case back to the Supreme Court of Pennsylvania for further proceedings. The Supreme Court of the United States cannot order the Supreme Court of Pennsylvania to decide a certain way, but they can encourage that they do so. Once again, the Supreme Court has placed the interests of law enforcement above those of the general public. While I believe the vast majority of law enforcement are honest and honorable people trying to do a difficult job, there are those who use the badge as a power trip. They believe they have the power to order people around without reasonable cause, and this case reinforces that belief. The saddest part is that this case is not law. Neither does it supersede the Constitution of the United States. That means law enforcement, who took an oath to support said Constitution, needs articulable reason to order anyone around. Yet law enforcement and courts still infringe on the rights of the American people because of this case. To me, this is why it is so important that everyone read and study the Constitution, because we cannot trust that the judicial system is familiar with it. Pennsylvania v. Mimms. Another example of a bad decision turning into bad precedent, which people treat as if it were law. I only wish more people realized it was not. In order for any government official to seize you, to order you around, they must have a reasonable cause of doing so. They must be not only reasonable, it must be articulate. They must explain why, before the encounter, they had a reason to do it. Now, is officer safety greater than individual safety? Are you telling me the safety of the officer on the side of the road is worth more than the safety of the individual in the driver's seat? That you can be ordered out of your property because an officer feels like it? Again, why not just go to the other side of the vehicle? I've seen it done. Yes, we have the question of unseen movements, but are you telling me that every traffic stop is a stop of a potential felon? That's basically what they're saying, is we need to treat every stop as if it's a potential felon, otherwise we might get hurt. What about the injury done, not just to the body, but to the rights of the person being pulled over? Sadly, this is the state of affairs of what we laughingly call our justice system, our jurisprudence. It's neither prudent nor just to say you must get out of your vehicle because I feel safer with you on the side of the road. It's never happened to me. I've been pulled over a couple of times. I've never had an officer ask me to get out of the vehicle. I pray I never do. But if Pennsylvania v. Mimms is to be held above the Constitution of the United States, which says you cannot deprive me of my life, liberty, or property, including my liberty to sit in my car without due process, a process designed to protect my rights, well, there's a problem. The system is broken, and it's one that we need to fix. I hope you'll continue to follow the work that we're doing here. And I found this little course called The Miracle of America. It's kind of cool. It's the history from the United States through the drafting of the Constitution. It helps explain why the Constitution looks the way it does. I liked it so much, I made a deal with the publisher to get you a lesson absolutely free. Just go to constitutionstudy.com/1776 study guide. You'll be taken to a custom landing page just for Constitution Study listeners. And you can read up more about this. More importantly, you can enroll for your free lesson on God's natural law. The lesson is free, the downloadable study guide is free, and you can watch an hour of video or listen to an hour of audio absolutely free. And if you like the course and you want to take the rest of it, the whole thing is just $17.76. Not a bad deal. I also love the idea of supporting companies that, are out to protect our rights. One of those is Patriot Mobile, America's only Christian conservative wireless provider. They support organizations that are defending our rights, like Folds of Honor and the Constitution Study. That you can get great 4G and 5G service with the same towers and the same networks that the major carriers use, but protecting your rights rather than infringing on them. Just go to patriotmobile.com/constitution, find a plan that works for you. Check out the discounts too for NRA members or just families with multiple lines. Most importantly, you'll not only get great wireless service with great customer service, but you'll be helping defend not just your rights, but the rights of your family and your neighbors. Again, that URL is patriotmobile.com/constitution to find a plan. And don't forget to use the code Constitution at checkout to get free activation. Most of all, I hope you'll come back and join us here. I hope you'll share the work that we're doing. Share it online, share it with friends and family on social media, wherever you can. But I hope you'll come back to join us here the next time we meet for the Constitution Study.